Good morning.
Bonjour. Bonjour, chers amis. Bonjour, chers invités de notre famille politique. Il est bon de voir tant de personnes ici, tant de personnes intéressées, et c'est un plaisir de vous inviter à ce symposium de notre groupe SED sur la jurisprudence portant sur la directive salaires minimaux. Vous vous en souviendrez, en novembre passé, on était déjà ici et beaucoup d'entre vous étaient présents lorsqu'on s'est penché sur la mise en œuvre de la directive et lorsqu'on a analysé son impact en Europe. Lors de cette conférence, on a entendu de très bons exemples de l'impact de cette directive en Pologne. Il y a une augmentation de 21% du salaire minimum.
The double DC threshold for minimum wages was incorporated in the national law of Bulgaria directly, and it resulted in an 80.2% increase in Bulgaria's minimum wage. And for us, I mean, it's very clear that minimum wages are the safety net. They are the basic line. What we aim for also is that at the same time we need to strengthen the collective bargaining very much wherever possible, and therefore also the minimum wages directive threshold of 80% collective bargaining coverage rate is one of the important steps also on European level here, because if we talk about the quality of work in Europe and that we want to increase it, we need clear targets, and we will discuss it, we'll need clear tools to achieve that. Because in the end, when the directive was started, we were in times of inflation, of rising costs for living, that it is very important that in the end that the citizens, the workers, have more money in their pockets, also to have a decent life here. And this is also, and we always emphasize this, very important for women, because when we look at minimum wage earners, what we can see is that in average 50% are women, and we have some member states, some country, where it's even 2/3. And this is also that it brings more equality to Europe with this directive here. So when in January we learned of the European Union's Advocate General that he advised the Court of Justice to annul the minimum wage directive, this was really first moment like a shock. On the other hand, also that we immediately said we have to look at this. This opinion is not unchallenged. Let's, on one hand, deepen our debate with distinguished legal experts also on that, and on the other hand, let's get also prepared what it could mean if the worst case would happen here. And this is why I'm so happy that we have some distinct legal experts here that will give us a bit more insight on the legal background of the case and also on the underlying arguments here. And also, I'm very, very, very happy, I have to say, also that we have Nicolas Schmidt here, who I would say, together with Agnes Jongerius, was, don't be embarrassed when I say it, I did it before, like the father of this directive. It took...
We are both the parents.
Yeah, Agnes and you are the parents. We agreed on that one already some time ago. But I think for us, it was one of the big social progress that was achieved on European Union level. And as I already said, it came timely, and it was also a huge battle. It was a huge battle of the trade unions that paved the way for these debates for many, many years, and also to have the majorities in this House to achieve it. And this is why the debate is very important, because we have also seen that already this opinion of the Advocate General created a lot of insecurities in some member states, like in the Netherlands. Everything was stopped regarding minimum wage directives, and this is also why it is so important to deal with it and here to discuss it. So with Nicolas Schmidt, I wanted to give him also the opportunity. We also know that a lot of legal expertise was used when the directive was developed. So if you could give us also some insights about this process, and this will then be a good basis to discuss with our legal experts in the first panel on this, and then in a second panel go on the political implications and what we can draw out of this debate with Nicolas and then with the legal experts. And what we want to achieve, this is already a little threat to you, we want to be as inclusive as possible with questions, with debates here, with you all as guests here. So Nicolas, I'm very happy to have you on my left side now.
Yes. Yeah, that's true. It's not so easy to be on your left.
and to enlighten us here about this. You have the floor.
Yeah, to this very important conference and listening now your introduction, I even have the feeling that it's more important than I had expected. It is a great pleasure to meet you again, and I must confess that sometimes I miss you. So this conference is about one of the major achievements, and you mentioned it, of the previous mandate. It marks a decisive step into the direction of a more social Europe. It definitely establishes a new balance between the internal market, competition on the internal market, and social progress for all Europeans. It considers that there is a need for regulating competition by promoting real social convergence. Social convergence may have multiple aspects, like working conditions, social protection, labor rights, but for me, it definitely, and you said it also, starts with fair wages and the way how fair wages are set or negotiated. We thought that with this directive, we had found the right way to implement principle number 6 of the European Pillar of Social Rights. And I just quote briefly, workers have the right to fair wages that provide for a decent standard of living. In work, poverty shall be prevented. All wages shall be set in a transparent and predictable way according to national practices and respecting the autonomy of social partners. These objectives were achieved, though taking into account, and you mentioned that, the limits of the treaty. We were absolutely aware that we were not totally free to go, I would say, as far as we would sometimes, or some of us would have liked to go. But there are limits in the treaty, but the limits do not mean that there is no possibility. So it was not easy to come to a coherent, effective directive. I must say we had a lot of discussions with the legal services, especially the legal services service in the Council, but also in the Commission. But I think at the end we managed to have a balanced outcome. And then a few months ago, you mentioned it in January, we were stunned by the submissions made by the Advocate General on this case, introduced by two countries I will not mention now, but you know them. One country followed by another. We suppose that these were made with complete impartiality and independence and were completely reasoned as required by the treaty. But these submissions are absolutely not equivalent to a decision taken by the court. And I think this is important. It's not a decision, it's an opinion, it's a submission by the Advocate General. So you can discuss it, you can criticize it, and you can also try to show that it is on a very shaky, and this is the least I can say, on very shaky legal ground. That's why it is right and timely to analyze these submissions and even to criticize them. A number of articles written by prominent labor and European law specialists have done so, and we will listen today to other opinions, and I'm very confident that they will show that what I mentioned as shaky ground is even more than that. And all this, or most of these articles, which have been written on this opinion or submission by the Advocate General, come to the conclusion precisely that the arguments are not really relevant. So the point is about competence, as always, contesting the competence of the union to intervene in the field of wages, 153, Article 153, and especially the provision that first, you know that we cannot set wages. I have read the directive a lot of times, I must say. I have not found any setting of a wage, a European wage, in the directive. And the other point being that we have no competence, or at least not with majority voting, on dealing with collective bargaining, because this should be dealt with at least by unanimity. But here also, we are not really interfering into this aspect. We are just responding to something which is natural, because in some countries there is no statutory minimum wage, there is only collective bargaining, and that's why if wages have to be fair and adequate, well, we should also look how this collective bargaining functions. And it's up to the member states to make sure that there is a real bargaining on a fair basis, on equal standing of the two parts, the employer side and the employees side. So I must say the annulment which is proposed here is something very serious, and okay, we should not anticipate the conclusions of the court. I believe that first that it has happened quite a few times that the court has not followed the opinion of the Advocate General, and we think that this might happen again. And again, I would say that when we drafted the directive and when we negotiated also in the trilogue, it was not easy with the member states, and well, we always had in mind the limits. And I must say at the end, we got the blessing by the legal service, especially of the Council, but also of the Commission, and perhaps more easy, the one of the Parliament. So this directive represents a significant step toward achieving wage adequacy across the EU, but it is not without its limitation. That's written in one of the articles. And I think this is exactly what we have in mind. So I will not now go on arguing on legal ground, because there are people here which are much more competent than I on giving the right arguments and the right analysis. I will try to set it into a more political and economic context. And I have a few points I want to make what this directive means in the political, economic context, especially the context we are in now. You already mentioned, Gabi, that when the directive was elaborated, when it was worked out, it was COVID, and after COVID, it was inflation. And finally, a lot of member states, I must say, were inspired by the directive in some way to say, well, we have to do something about wages. Because if wages are falling and falling, real wages, this is bad socially, but, and that's my argument, it's also bad economically. So my first point, I would say we are just coming out of this period of high inflation, and wages have not, or in many cases, hardly recuperated in most member states. So we have not seen this explosion of wages. And we know that the central bankers are always very, very nervous about wages when they look at the figures and they look at the inflationary anticipations. Well, it has not really happened. And we had improvements at the wage front, but finally it had not this inflationary pressure which especially central bankers, but which everybody should be aware of. So that means that for millions of Europeans and their families, their living standards have worsened. At the same time, they see the wealth, and here we have to say it as social democrats, they see the wealth of a small minority exploding. The COVID has been the source of an incredible wealth increase of some small minority in our society. Bonuses in the financial sector, for instance, have recovered quite dramatically, I must say. Dividends have never been so high, and share buybacks, billions and billions of share buybacks, make shareholders and top managers richer instead of taking this money and invest in the transformation, especially also the green and technological transformation. So the consequences are obvious. Inequality is on the rise. We have not managed to diminish inequality. A majority of working people have more and more difficulties to make ends meet. This is not good for social cohesion that we need more than ever in this political, very critical times. Cohesion inside our societies, rising populism, but also convergence between our societies, which means that there are evolutions in our union which go in different directions, which is bad, precisely also at this moment where we need more cohesion, more solidarity inside the union. The second point I would like to make is the directive aims at minimum wages first, but many minimum wage earners are close to the poverty line. So even there, where we have minimum wages, we see that the poverty line is very close to the minimum wages. Even in my country, that has the highest minimum wage, well, the minimum wage is quite close to the poverty line. So in-work poverty affects more than 10% of the working population in Europe. And I just quoted the principle 6 of the pillar, which says preventing in-work poverty. A majority of women, and you mentioned that, exactly, a majority of women in different, typically so-called female professions are suffering under these conditions. Part-time work plus very low wages, sometimes no collective bargaining, and if minimum wages, then very low minimum wages. So, and this is a real concern, not just for equality, but also for these sectors. And one of these sectors is care. And the previous commission dealt with the care sector. And there is really an issue with the care sector in all our countries for obvious reasons, aging population and so on. So I stop there. The third argument, today, the commission as well as member states are very much focused on competitiveness. And I do not question that. But competitiveness, I always ask, for what, how, and for whom? For whom? The Draghi report that presents a very topical analysis leaves the social issues aside. This is regrettable, indeed, but at least it does not link low wages to competitiveness. Its main focus is on productivity, and I would say rightly so. And allow me to quote one sentence in the out of the Draghi report. I quote, "Competitiveness today is less about relative labor costs and more about knowledge and skills embodied in the labor force." That's Draghi. Yes, we agree with him on that issue. Investing in people, offering good training and upskilling opportunities is the key for higher productivity. If wages should follow productivity gains, we have seen that during the last years, this has generally not been the case. And the conclusion, I would just show you and quote a book by a French economist who is not a leftist guy. He is the economist of an investment fund, chief economist, and he published a book saying 40 years of wage austerity, showing the harm this wage austerity has produced for our European economies. And again, I must say that Draghi made a speech here in Brussels before presenting his reports. And he quoted a certain number of reasons and causes why, finally, Europe is running behind in terms of growth. And one of his reasons was to say, well, Europe is lacking purchasing power. Wages in Europe are too low. And I think this is a very, very important argument to say, well, we have to work on a new share between productivity gains, but also on the wealth between labor and capital. So if we want our competitive objectives to succeed, we surely have to invest more, to innovate more, but above all, to have a fairer share between capital and labor. That's what the European model should stand for. That's the objective of social Europe this directive is an essential building block of. Wages are crucial economically and socially. It should be a major mistake precisely in the present political and socio-economic context to consider that after 5 years of obvious social progress, building a stronger social Europe, it is now time for pause, or even worse, for social deregulation, called simplification. But we all know what these words are hiding. And this is not the right way to make Europe stronger economically and politically, to rebuild an industry in Europe. Low wages are not only socially unfair, they are also bad for growth. I just quoted Draghi. Wages are not only a cost, the cost of labor, they are also a major source of domestic demand. This was also clearly underlined by Mario Draghi, I just mentioned. And the too low wages, wage austerity, to quote Artus, has and had a negative effect on growth in Europe. The economic model based on growth through exports. That was the model, especially during the financial crisis. We were told that was the solution. Yes, increase the growth, the exports. Now, in the new geopolitical, geoeconomic context, has new limits. So what Europe should rely on much more is their own internal market. And that's why I would say there should be 3 dimensions. Yes, Draghi's report, which is very much aimed productivity, technological, and innovation and financing that. That's one. The second one is let us report on the internal market, more than a market. And the third should be fairness, social and social dialogue. And that's my last point, sorry. My last point is about the social dialogue dimension. Well, I have produced a recommendation on social dialogue, fine. But I have to question myself, did the Commission, even the previous one, did we really practice social dialogue? And I would say, not really. Because we had a project of transforming our economy totally from scratch to change fundamentally our economy with the Green Deal. How much did we involve? Really not these nice speeches at the trilogues with social partners. Everybody is reading the speech and saying, well, tapping in it. No. Had we really a social dialogue to build this new economy? No, we did not have. Now I notice that we have structural dialogues. But things have already happened. Problems are there. You should prevent problems by having a real social dialogue when you are planning, not when problems have already arisen. And I think, by the way, I will stop here. This directive is on collective bargaining, on social dialogue, but there cannot be a fair collective bargaining if especially the trade union side, which let's say in most cases are the weaker party, if they have not the full rights. And that's what, finally, to have a fair negotiation, to make fair deals. Although I hate this word of deals. Yes, I hate it, but I say it on purpose. That you have to make sure that there are good conditions for negotiations. There are clear rights. And the aim is not to change a system, but just to allow fair wages also through collective negotiations. Now, it's up to us to implement the directive, we have discussed that, and to fight for its, in some way, survival. Thank you.
Thank you very much, Nicolas. Not an inch less passionate about the topics than when you were commissioner. I think that's a good signal. It shows that it's an inherent thing. So thank you very much for this speech, also highlighting again how this directive was built. It was developed, and I'm very happy that we can now invite here our speakers for the first panel to join here, and you can also stay here. So I invite Professor Nicolas Contouris from the University College in London. I welcome Stefan Klaubert, whom we know from the ETUI very well, and Professor Roland Oerne from the University College in Dublin here. And you can imagine that we all here are very eager to hear from you as experts, how you assess the case here, and also what could be points and arguments that were not taken into account sufficiently so far to enlighten us here. So you know that you all have 8 minutes, and I know this is asking a lot here for your expertise here, but also that we have time for questions and debates afterwards with the audience. So we start with Professor Contouris here. You have the floor.
Thank you very much. Thank you for inviting me to this symposium. I think no social lawyer in Europe would ever have wanted to be invited to a symposium on this topic. And I think it's a great surprise that we're being invited here. This is, I think, a once-in-a-generation event, especially in terms of the possible implications of Advocate General Emiliu's opinion. As we all know, the Advocate General has advised the court to annul the directive in whole or in part by reason of being ultra-virus, that's to say, having been adopted in breach of the lawmaking powers that the treaties give to the Parliament, the Council, and more specifically in breach of the pay exclusion contained in Article 153, paragraph 5 of the treaty. The opinion also raises, albeit a number of other important questions and indirect challenges, for instance, to freedom of association, collective bargaining, trade union autonomy. I will not deal with those. They're not central to the key ultra-virus claim. And I'd like to refer you to the very comprehensive ETUC counter-opinion that addresses them all very systematically. I will only focus on the core contention of the Advocate General, that the directive as a whole, or alternatively just its Article 5, most of its Article 5, should be annulled for being in breach of the pay exclusion. I will try to explain to the best of my abilities, because I don't necessarily agree with the AG, how he reached the conclusion. We then briefly say how the pay exclusion should be interpreted on the basis of established precedent, and then briefly discuss some of the implications, although you already heard a lot about that from the two previous illustrious speakers. So the Advocate General reasoning first, in summary. So he says that the pay exclusion refers both to the idea of a level of pay, okay, but also, and crucially, to the modalities or procedures for fixing the level of pay, which according to him are also prohibited by Article 153. So you can find this around paragraph 54, 59 of the opinion. I won't comment on the reasoning of his reasoning. I don't find it compelling. It's not based on the wording of the treaties, I should say. It's not based on any precedent of the Court of Justice. It's his creation, so to speak. The second step was to expand the exclusion, the pay exclusion, even further by introducing a very broad direct interference test that the Advocate General extrapolates from precedent but genuinely expands, and suggests that this test is met by an instrument such as the Adequate Minimum Wages Directive if its object is to regulate pay, no matter how strictly or flexibly, okay? And then he contrasts this with other EU directives that may have an indirect interference with pay. For instance, the Equality Directive, the Part-Time Work Directive, I suppose the Working Time Directive, whose object is to regulate a matter other than pay, are only indirectly interfering with pay by having mere repercussions on the level of pay. This is, he's really treading carefully with words, but he's really demanding a genuine expansion on the direct interference test, to the extent that it was a test before, but he's made it a test. So those directives can pass the test, but the Adequate Minimum Wages Directive cannot pass the test. He's particularly concerned about Article 5.2 and the criteria there, but also clearly Article 4 and 12 for this direct interference. Thirdly, the Advocate General has opined that the protection of the contractual freedom of the social partners is not the only rationale, which we know about, for the social exclusion. To this rationale, he adds three more to the pay exclusion. Maintaining competition between undertakings operating in the internal market, this is new, you don't find it in other case law. The fact that wage policy is a sensitive area, so there is an exclusion. How many policies are not sensitive? Yeah, I didn't want to get.
It's also very sensitive.
And the diversity of national collective bargaining and industrial relations systems, of course, yes. So it's fair to say that the Advocate General has engaged in some, I think, creative interpretation here, expanding on precedent. If one looks at the four previous cases that the court where the court has engaged with the pay exclusion, these are Del Cerro, Impact, Bruno, and Specht, there is a stark contrast between the much more cautious and conservative approach of the court and the much more expansive approach recommended by the Advocate General. I will briefly elaborate on the criteria that emerge from precedent and contrast them with what the Advocate General has done. Firstly, the court has repeatedly said that the pay exclusion is an exclusion And therefore, like all exclusions and exceptions to EU law, it must be interpreted strictly, narrowly, okay? So since paragraph 5 of Article 153 derogates from, in particular, paragraph 1 and 4 of the article, the court has said that the matters reserved by that paragraph must be interpreted strictly so as not to unduly interfere with the scope of paragraphs 1 and 4, the previous areas of competence, nor call into question the aims pursued by Article 151. So interestingly, the Advocate General acknowledges this principle, but then he does something completely different. So for example, as I said, he goes on to expand on the rationale for the pay exclusion. He had 3 more rationales, including this competition between businesses that is very new, expands on this idea that it's not just the level of pay, but also the modalities or procedures for fixing the level of pay that are covered. He also expands on the measures that are caught by the exclusion compared to precedent, because I think he does not calibrate properly this direct interference test. So while the court has established that exclusion applies and therefore prohibits, and I quote, measures such as the equivalence of all or some of the constituent parts of pay or the setting of a minimum guaranteed wage, which would amount to direct interference, he expands this both to the modalities, but also includes within these modalities the provisions contained in Article 4 and 5. Now, there is a question here about what the word equivalence means in the precedent of EU law. In the English version of the decisions, it's not very clear, but if you look at the French translation, the word that is used is uniformisation. So it's only measures that create uniformity in the levels of wages that, according to precedent, are prohibited. If you read the French, the Italian translation, the word is much clearer than the English equivalence term. And I think it's clear that the directive doesn't do that. So the extensive interpretation of the Advocate General and its implications are all too obvious. He wants to annul the directive. There are, I think, implications for other directives as well if his approach passes, okay? And for other policy and regulatory objectives. The Posted Worker Directive arguably engages with not the level of pay, but also with measures on establishing the level of pay, or mechanism. I hate to say this, but you know, the Pay Transparency Directive does that to a certain extent, perhaps even the Public Procurement Directive. Now, I conclude. I've been asked, is this a political opinion? What are the implications if the court accepts this? Now, it's difficult for me as a lawyer to answer these questions. What is clear is that when it comes to challenges on competence questions, traditionally the court has been very cautious, okay? The court has typically, the successful claims, which were quite egregious, can be counted literally on the fingers of your hands, one hand. So it's very rare. Typically, what the court is asking for is for the lawyers to present to them a credible alternative to the one presented by the member state, or the Advocate General in this case, that is seeking the annulment, okay? And this is what I tried to do. But we are in atypical times. We've heard it, so we need to be careful. Perhaps we need more than just what I've suggested, which is an alternative reading to one proposed by the Advocate General based on precedent. Perhaps we need something more compelling, both from a legal point of view and from a political point of view. So this is a good initiative, if I may say, at the right time. And for the more compelling legal arguments, I think this is exactly what Stefan will do in his presentation. And again, may I refer you to the ETUC counter-opinion produced by its lawyers for that. I'll stop here, and I very much look forward to hearing from him and Ronald. Thank you.
Thank you very much. That already would give a lot of room for debates, but we want to continue before we do it. You already did. I mean, I'm not necessary as a moderator because you already mentioned, and that was really good, Stefan Klauvert, who can really pick up there. And you have the floor now, Stefan.
Thank you very much, Gabi. Good morning to all of you. Like Nicola would say, thank you for inviting me, but to be honest, I'm part of that group of people that had never expected to be here, let alone invited for such a debate. But having said that, and building indeed the bridge to what Nicola already hinted upon, together with a team of lawyers, the EQC has, after it has been starstruck as well by the opinion of the Advocate General, has put together a so-called counter-opinion, which is the fruit of hard work by several lawyers inside and outside the EQC, to name a few: Klaus Löscher, former legal referendar at the court himself, but also the DGB lawyer, and Lord John Handy, QC. What we try to do there in this counter-opinion is basically to dismantle the many flaws, the many inconsistencies, and the many contradictions, even in the very, you could call it creative opinion, but for me, rather, or for us, it's a rather also cherry-picking opinion in the way the Advocate General argues. And our main arguments against the argumentation lines of the Advocate General can be divided in two groups: some general reflections and arguments, and then what I would call some nitty-gritty legal arguments based on some specific topics that the Advocate General is further elaborating on, such as the pay exclusion, the freedom of association exclusion, etc. But let me start with the general reflections, the general counter-arguments, which we can summarize, I would say, at least from our point of view, to have a complete lack of contextualization of this case and of this directive within the social policy field and within the treaties overall. Firstly, a lack of contextualization by not taking sufficiently, at least, into account the vast international European human rights framework which is out there. We have listed them all in our counter-opinion, just to give you an idea on how fundamental the right to pay and adequate pay is in international law. He does not even bother, apparently, about ILO conventions. He does not bother about the European Social Charter of the Council of Europe, which, by the way, is in Article 151, which is the article before 153 and the founding source of 153. And I can go on. He doesn't really refer to the Charter of Fundamental Rights of the European Union, let alone the pillar. And if you look at the part of the relevant law, if he quotes Article 153, he even is cherry-picking there because he doesn't refer to the paragraph where it says that, for instance, member states can leave the implementation to social partners. So the collective bargaining element. Second lack of contextualization, the EU constitutional framework. He's right. This is a matter of constitutional nature, referring to Article 5, paragraph 2 of the treaties. But, dear Advocate General, there are also some other fundamental articles in our treaties which stipulate the objectives, the values of the EU, and which refer, amongst others, to the rule of law, human rights respect, but also social objectives, social progress, etc. A third context, which we think he is omitting, is the historical one. He seemed to have found no evidence in the travaux préparatoires to the treaties that pay has to be read restrictively or otherwise. Well, some scholars have done that research, and it proves that the founding fathers of that article, the member states thus, there were different opinions on how to read and how they wanted to have pay mentioned in that article, from no exclusion to a very limited exclusion. There, they didn't find any proof of the very extensive interpretation that had to be given to that notion of pay. The same goes because the Advocate General is not looking at it from a social perspective, but rather an economic internal market perspective. There is no proof that the driving forces behind that issue are economic. On the contrary, it's all social drivers which they had in mind when drafting this article. Last but not least, as I said, a lack of constitutionalization also of where does this directive fit in. The directive fits in the social policy title. It is a direct action to what the EU did to us, to workers, and to pay under the economic governance, i.e. the European semester, where they dismantled collective bargaining systems and where they asked heavily for wage reductions. Last, but then coming to some of the specific reasonings, the too wide interpretation of the pay exclusion. Yes, you're right, the Advocate General acknowledges the restrictive line of interpretation as it was taken by the court, in general and on Article 153, paragraph 5. However, he does so by referring only in 2 paragraphs, a little bit more specific, to one case. He omits referring to the founding case, which is Del Cerro Alonso, where the Advocate General had the same wide interpretation, but was overruled by the court. Hopeful message also to Advocate General Emilio and the court. So apart from recognizing this restrictive line, he says, yeah, but we should not do it too restrictively. Otherwise, we undermine Article 153, paragraph 5, the exclusion. So I will boldly go where nobody went before, and I extend it, as Nicolas said, to all aspects of minimum wage setting or wage setting by member states, including the modalities and the procedures. I'm sorry, but this is then contrary to the second part of the standing case law, which says, but you cannot avoid that, you cannot do anything on pay. Any sort of link should be also not excluded. Fine. That on the too wide interpretation, but what is more important is that with this wide interpretation, he dismantles and empties Article 153, the body of that social policy title, and we can ask ourselves, is he not saying here we can not protect as EU wages, certainly not under the social policy title. So where are we going to protect it then? And what will be the impacts if the court sticks to this wide interpretation? What will be the impact for future EU law, given already the difficulties, as Nicolas Schmidt has explained, we had for this particular part? So then something strange happens in the opinion, where he says, I'm throwing open the pay exclusion. The other one, however, I keep restrictive, the one on freedom of association. Why? Because the court has not expressed itself yet. Okay, that might be a reason. But his main argumentation is freedom of association, for instance, cannot be too widely interpreted, and thus it cannot indeed cover collective bargaining, because collective bargaining and freedom of association are regulated in 2 different articles, okay, in the Charter of Fundamental Rights of the EU, and it's also regulated or nominated differently in 2 separate parts of Article 153, and he makes a little jump to the neighbor in Article 156 on the cooperation between member states, where indeed freedom of association and collective bargaining are mentioned separately. But question is, why do you make that jump to make your arguments on freedom of association, but you forget to look next door when it comes to the pay exclusion? Why didn't he look to Article 157 on equal pay for equal work, where not only we have a nomination, equal, but also we have a definition of pay, including a reference to minimum wage? Very strange, very cherry-picking. Last but not least, we also consider that apart from that exclusion of freedom of association, he has a very narrow view on what autonomy of social partners is when he looks at Article 4, paragraph 2, and the whole directive in general. He doesn't refer at all to the different safeguards, the different flexibility provisions that allow collective bargaining and that allow social partners to intervene in that directive. But more importantly, he also seems to look at Article 4, paragraph 2 as limiting, restricting the collective bargaining possibilities. I beg your pardon, but he loves literal interpretation when it comes to pay. The title of that article says promotion of collective bargaining, protection of collective bargaining. So why we should not read the EU law only in one way. And that is particularly what he's doing on several occasions, thereby also omitting, I would say, the general line of interpretation by the Court of Justice of the European Union, which states that when there are different interpretations for a text of EU law, or the text is unclear, then you have to look at the context and the objectives in which this EU law is adopted. I'm sorry, I think I demonstrated at the start of my presentation that this is exactly what the Advocate General has not done, taking into account the objectives and the context in which this directive was concretely elaborated. I will stop there, maybe with one more thing. What bothered me even more within his opinion, to be honest, is I was at the hearing and the member states, Denmark and Sweden, were questioned on whether they still had a problem with Article 12, so the individual possibility for a redress. Both countries said, no, it's solved. The text as it is now solved our problem. What does he say in paragraph 94 of his Advocate General opinion? Article 12 is problematic for member states such as Denmark and Sweden. Sorry, I mean, a certain degree of honesty would be appreciated, but apart from, of course, taking another approach to this very important directive and the principles and objectives it tries to protect. Thank you very much.
Thank you very much, Stefan, for this condensed and very rich analysis here that on one hand makes some of the points, as you said, lack of contextualization, etc., is very important, but also you give some hints of hope in your analysis with this as before. But I would like now also to give the floor to our next speaker, Professor Erne. You have the floor.
Thank you very much. I start with first a thank you to you for inviting me, but then I must make even a much bigger thank you to all of you in the European Parliament that allowed me to be here, because we had the privilege, thanks to the European Parliament, to study for 6 years as part of a ERC-funded project, Labour Politics and the EU's economic governance regime, from the financial crisis to the COVID emergency. And we just published our book and we thought, okay, job done, now we can relax. But then we were surprised by the January opinion of the Advocate General, and then I felt triggered. Maybe we have something to say about what has happened in the last 20 years that could be useful. So maybe there is fundamental empirical research on EU law, labor policy, and labor politics can make a contribution to the doctrinary debates and different debates between different legal interpretations of the article. So this presentation is not a law presentation, but a presentation on the law, labor policy, and labor politics. I build on what you have just heard, and I will focus on one or two aspects and go a bit deeper. The first is, what is actually bargaining autonomy? When you read the Advocate General's opinion, you see that he himself is quite honest by saying, yeah, I'm actually speculating. So I've not been able to find any statement on why to protect the contractual autonomy of social partners. But then he, just out of the blue, states, in fact, it's certainly the case that by preventing the harmonization of wage level applicable to each member states, the pay exclusion contributes to maintaining competition between undertakings operating in the internal market. Okay. Is this really the goal of bargaining autonomy? And if yes, why did the Conservative government not support it? And indeed, if you look at the fundamental research also of colleagues like Kilpatrick and Steyer at the European University Institute that also had a lot of money to study the European history that you referred to in these fields, they highlight that in yours, the particular constitutional source of the social title in the European Treaty. First, it's actually all started with an agreement among the social partners. So it's not a typical intergovernmental compromise. And then second, it is based on the social policy agreement that the UK government did not sign. And why did Margaret Thatcher and her John Major not sign it? Because this social policy title aimed to prevent social dumping, to secure union support, worker support for the single market project and the European Monetary Union. So the whole title is inspired by the idea of upward convergence of living and working conditions alongside, not against, bargaining autonomy. So it's wrong to say that this clause, as Emiliano says, is there to limit or to increase competition. No, the opposite is true. So the whole title, the idea is to limit regime competition between national bargaining systems. And we have seen, and already mentioned before, many laws with provisions on pay since the 1970s. So other colleagues, as Kilpatrick and Steyer, also an Irish colleague in Florence, and a German-French colleague, there is a consensus among legal scholars that the opinion rests really on very precarious grounds. It neglects the drafting history of the treaties, existing labor laws, and the court's own case law, which already regulates pay in ways that under Emiliano's interpretation would be prohibited. So we can say, and all legal scholars would agree, that the court should maintain its established approach in narrowly interpreting Article 153.5 and reject the annulment request. But then there is this strange title. What do Kilpatrick and Steyer mean with a little learning is a dangerous thing? And that leads me now to the more labor politics part of my presentation. Emiliano argues, to my knowledge, the directive is the first legal instrument at EU level in the field of minimum wages. My Irish compatriot Kilpatrick, although I'm having a very Germanic accent, so while I became Irish just a few months ago, this is a very little learning, truly. So they argue that a little learning is truly a dangerous thing because what Emiliano is stating that goes against what many European citizens have experienced in terms of minimum wage policy and European Union interventions, especially in Ireland, but many other countries as well. But on the other side, it's also true in favor of Emiliano. When we went to Brussels in 2019 and we talked to Business Europe leaders, they were really certain that they will kill the directive with legal arguments. but they failed miserably in the democratic process. Why did Business Europe, although a very strong lobby, fail? They were not used to that. They were really surprised. Why did they fail? Why did their legal argument not work? And the argument is the employers themselves undermined their own legal argument with their own political actions. If you go to the financial crisis, it was Business Europe that called for greater EU powers in labor policy. Why? Because in the crisis, we saw that the market, as also a DG ECFIN official that we interviewed told us, the market didn't work. It didn't create convergence as the treaty said it should. It didn't follow the law, the market, but it created major economic imbalances. And then as a result, we have seen a major shift in economic governance, and the EU adopted a new economic governance regime, which was there to create the convergence by political means. So a Troika representative in Ireland said at the height of the financial crisis, we understand the market does not work. That's why we are here, to integrate, to do what the market should do by political interventions. But by doing that, the employers and the new economic governance regime made wage policy a European issue. So some people argue that's not EU law. No, unfortunately, it is EU law, and the court has acknowledged that it is EU law. The council decisions in the Troika programs in Ireland, but other programs in Romania, and then also the institutionalization of this new economic governance regime by the six-pack on economic governance has made wage policy a European policy issue. So how can Emiliano say that the EU lacks the authority to adopt a decommodifying minimum wage directive after a decade of commodifying EU governance prescriptions on wages and collective bargaining mechanisms? We have shown that in our book very meticulously on the policy interventions in 4 countries: Ireland, West, Romania, Germany, and Italy. Of course, the power of these prescriptions are not the same. It depends in which economic conditions you are as a country in a particular situation. But when you are in a particular situation, so to speak, these prescriptions are more constraining than EU directives. So that is why Esther Lynch, for example, who used to be Irish Congress of Trade Union legal scholar during the Troika years, she said, you cannot do that to us. There is wage policy is a protected areas, etc. But all the arguments failed. Colleagues, trade unionists in Portugal and Romania went to European courts. They all lost because the court argued in all cases, no, economic stability is more important than these points. So that is important, as I said, because these new economic governance prescriptions don't have to be. In Germany, they have not. They have been weak. But if a country is in a MOU agreement or in the coercive arm of the macroeconomic imbalance procedure or the coercive arm of the Stability and Growth Pact, they are more constraining these prescriptions than the EU directives, even if the EU directives are actually more democratic, because you, European Parliament, you have a say, but you don't have a say on the decisions of the Council of Finance Ministers to prescribe wage cuts as it happened in Ireland and other places. So what's the outcome of this? If Emilia prevails, which everybody tells me he won't, okay? But if he prevails, the popular legitimacy of the EU will be in tatters. Workers won't understand why business-friendly EU governance prescriptions on wage cuts and the marketization of collective bargaining mechanism, decentralization of bargaining, they are legal, okay, but a labor-friendly directive who tries to provide a framework for adequate minimum wages is not legally possible. Thank you very much.
Thank you very much, and this gives us the opportunity for a debate and short and concise questions. But before we do so, I wanted to inform you that also online connected, we have 330 people who are also interested in this debate. And we can see there is a high interest here. So who wants to ask a question? I would like you to present yourself, have a short and concise question, and also to whom you address the question. So who wants to break the ice? Yes, go ahead.
Good morning. I'm Ricardo from the Spanish Socialist Youth and from the College of Europe. And I would like to ask you, what has been the position of the Scandinavian governments in the Council on regards to the news of the opinion by the AG, and what has been the opinion of the Socialist Party of those Scandinavian parties on regards to this position of the AG? Thank you.
I think we collect some questions. If there are more, yes, please go ahead.
Oui, bonjour. Moi, j'ai une question concernant le...
Thank you. I've got a question about the minimum wage. I think there's going to be a trend for private companies to take on more and more people on minimum wages rather than on a more normal wage. Of course, it's to be expected. Why should they want to pay people more? People have very low wages. They can't buy what they need. So my question would be, how are you going to fight against that trend? Because that is going to be a trend. Things are going to move in that direction.
Thank you very much. If we don't have any more questions, maybe you are too shy, but you can do. I have one question more. Yes, go ahead, Irina.
Hello, I'm Irina De Sancho. I'm an S&D advisor on employment and social affairs, and I thought it was very interesting that you are referring to the economic governance, the old economic governance that imposed deregulation and attack minimum wages. However, and thanks to our commissioner here and our vice president, who participated in the negotiation of the new economic governance, now I think there is also an argument there, because in the new fiscal rules, there is an obligation to implement the principles of the pillar. And one of the principles of the pillar is ensure decent minimum wages. So I think that this argument of linking wages with the internal market is also disqualified by what we have now in the new economic governance rules. And again, this was thanks to those two people that are there.
Thank you very much. And yes, I have one more in the back, and then maybe we do a final round here before we go to the second panel.
On the efficiency conversation, I think we've seen a lot of people take the Draghi report and instead of look at what it says, they have used this as a way to figure out how they can cut workers using AI, automation, and robotics. And I think this step forward into that direction puts us at a great disadvantage, not just in not protecting and building up our European capacities, but again, it puts us into a dependency upon American companies that would be providing these solutions. So where do you see your battle in fighting against this obsession with pushing for efficiency that's really just stripping laborers out of the labor market.
That is opening the debate quite wide, but it is an important point. If there are no more other questions, I will do one round, and we will start with you, Nicolas.
Of the two governments that that put the question of competence to the courts. First, I can say I had a lot of exchanges with these two governments. And what is their fear? What was their fear? By the way, it's not just the governments. It was also the trade unions from these countries, I have to say. Their fear was based, paradoxically, on the Laval Viking judgment. And the fear was always to say, well, you come with this kind of minimum wage directive, and what will happen? Somebody will go to the court, and then the court will decide that Denmark has to introduce a statutory minimum wage because one person is not covered by a collective agreement, a bit simply expressed. And we had a lot of discussions around that, and we really, and it was said by you, I think, that we prevented this case very clearly, and even the guarantee that no country could be imposed a statutory minimum wage is clearly stated in the directive. But despite of that, it became a crazy discussion fueled by some legal experts saying, no, all this is rubbish, this is not true. Well, if the court decides, the court has decided. So this was a very intense debate. These two countries voted, by the way, against the directive, but as it was a qualified majority, they just, that had no direct impact. But I can say my first visits as commissioner were to these two countries to discuss with them, say, okay, I understand, you have, by the way, I must say, I always told them, well, you have a very good system of collective bargaining. And if everybody in Europe had this kind of system, we would not need a directive, obviously. But unfortunately, many countries in the European Union do not have this system of collective bargaining. You have countries with 10% of collective agreements, at the same time, very low minimum wages. Last remark on minimum wage, yes, minimum wage is just a floor. And it's very dangerous. And there are some countries where this is the situation, where finally wages are tending to minimum wages. France is one example. More and more people being at minimum wage. Because in France, the minimum wage are indexed and the other wages are not. So at one stage, the minimum wage comes up to the level of lower wages, but wages which were above the minimum wage. So what we think is collective bargaining is the better way. So we have to promote really collective bargaining. And second, we have to promote the fact that the minimum wage never sets a dynamic of wages in the countries. If minimum wages are dynamic and improving living standards, well, if collective bargaining is developing, we hope that the overall level of wages is getting up. But if minimum wages stay very low, the other wages still stay very low too. So this is also, I would say, an argument or something, a reflection in the directive to create this wage dynamic, which we need to have fairer wages in Europe for social reasons, but also for economic reasons. I stop here.
So I will be very brief because all the questions that were asked were beyond my expertise, but I would like to agree with Nicola Schmidt, and I think there is here a dual target as far as this directive is concerned. Obviously, those who want it annulled would like to see the whole directive annulled, okay? They want to have that. But if they cannot get that, they're happy with having Article 4 annulled. And Article 4 is about promotion of collective bargaining. So that is the red line for those who want to halt the advances of social Europe. And I think from that perspective, for good reason, okay, minimum wages are very important, but the very transformative element of that directive is, of course, the promotion of levels of coverage of collective bargaining when they're insufficiently high. I think it's important to bear that in mind, also strategically moving forward in the ratification and implementation process of the instrument.
Stefan.
Yeah, maybe very briefly on, in particular, the last intervention, the reference to the economic governance systems, and in particular the old ones. Of course, that was because I said the minimum wage directive is an immediate reaction, I would say, that because of what happened in the old system of economic governance. And you're right, I mean, there might be a new clause in the new rules, but and create a kind of safeguard. The question is, how strong will that safeguard be? If it's not concretized by, in this case, a European directive on minimum wages. Nothing says us, nothing tells us, nothing guarantees us that despite the safeguard of you have to implement according to the principles of the pillar, that they will not politically decide otherwise. Secondly, and also coming back to what you said now, Nicola, on Article 4, maybe they would prefer to have at least Article 4 out, but what is paradoxical is that by asking to cut out Article 4, our Danish and Swedish colleagues in particular are cutting away a serious safeguard in this directive, in particular when it comes to collective bargaining. Because if you read Article 4, paragraph 2, it says, yes, member states have to. But then what follows is everything together with, or in consultation with, or by the social partners themselves. If that article drops, they have no guarantee that a member state, even their own, will intervene anyway without their involvement. So they are cutting away, or basically asking to cut away a safeguard which was built in, also on their demand for that matter, because of the percentage. Maybe they would have preferred 60 only, because if you look at the latest figures of Thorsten Müller, amongst others, they are very close to the 80. Which they would have not been with 60, maybe less problematic. So that for me is a little bit the paradox also of the second claim in particular.
Let me respond to 2 points. The first question about the Scandinavian Social Democrats and Scandinavian unions. What is important, you have responded already for the Swedish and the Danish unions, but we should also talk about the Finnish Social Democrats and the Finnish unions. They are very much supportive of this. Why? Finland is a Eurozone country and has been in the economic governance regime and understands what is happening there. Denmark is not threatened by any sanctions because under the macroeconomic governance procedure or Stability and Growth Pact, because sanctions only apply to Eurozone member states. So that's an important point. Second point, you are right. Yes, I'm very happy that Nicolas and his colleagues in the last commission turned the economic governance regime around. And we have seen that very clearly in Romania, where we have seen after 10 years a reversal of the commodifying labor law, the reintroduction of collective bargaining as a result of the conditionalities of the National Recovery and Resilience Plan. Very good. But when I met Nicola the last time in a plane, actually traveling first and last time from a train by chance, plane, yeah, from Romania to Brussels, I asked him for a surprise interview, and he gave it. And already there, he was skeptical and said, yeah, so progress can also be reversed. And especially progress can be reversed when the European Parliament has no say. These conditionalities are done by the Council of Finance Ministers and the European Commission. What guarantees us that this positive interpretation will survive? And actually, that is the point. Even if the conditionalities have been used in a progressive sense, it proves the point that the economic governance regime became more binding because now it's linked not to sanctions that is a kind of an atomic bomb. It's threatening, but maybe we don't use it against ourselves. But now we have the carrot. And the carrot is actually more dangerous, actually, than the atomic bomb in some sense, because now European executives can use it and say, oh, if you don't do this, then we don't give you funding. And the von der Leyen II Commission now says, we do these conditionalities now on all EU funding, including agriculture, including everything. So that gives, that strengthens this, and that's why Esther Lynch and many others really say the only thing that can help us is the European Minimum Wage Directive, because one thing that the Troika never did was going against secondary EU law. There was no Troika prescriptions against cutting the entitlement of paid holiday because it's a secondary EU law. There were other prescriptions that went against constitutional law at the national level. So that's why Esther Lynch, who was a supporter of this protection of collective bargaining argument, but then last said the only way that saves us if there is the next crisis, and unfortunately crises come and will come again, is to put these safeguards in the European Directive. So the European Directive is actually protecting, is actually doing what the makers of the social title wanted when they introduced the protection of bargaining autonomy or tariff autonomy at the time.
Thank you very much. And I think also already in this first panel, what we can see is there is one opinion, and there are also other very distinguished opinions. We heard about the evolution of this directive and what was already taken into consideration. And I think this will help us, and I will just take up a quote of you when you said progress can be reversed. That is the political context of it is the political context we are in at the moment, so we can also not in isolation look at the minimum wage directive. If we look at the overall context, it is even more important that we have this debate, that we shape the debates here, and that we also look at the political consequences of this. And this is why I'm very happy to hand over to our coordinator in the Employment Committee. And she will be, as the moderator of the second panel. I have to say, I thank you so much.
Thank you.
Very, very much. And again, it's a special applause for you, your arguments, which will help us that we have good arguments on our side. I also think for the ETUC to have this counter opinion is very, very helpful. So thank you to all of you again. And to Nicolas Schmidt also for having the courage to do the directive and joining everyone that has the courage to defend it. And we know why we are doing it. I think we have seen it also in this panel. So thank you very much, and we continue. Estelle.
Thank you, Gabi, thank you all. And I invite Mr. Müller and Isabel Schumann to join us here for the second panel. But allez, as we said, we are now at a momentum. Thank you, Gabi. About this directive, and second panel will look a little bit forward of the potential impact of the annulment of this directive. But first, I would like to have a last focus. It was already been said about who is the usual suspects who have to live now with a low wage in Europe, because it's also very important with what have been said in the first part and first panel. And I'm just looking to the last Eurostat statistic. This is not really the same statistic and level, because Eurostat use the median gross hourly earning, and the 66 median gross hourly earning. But at the moment in Europe, it means that 1 out of 7 worker is at low wage and have to be sometimes under the poverty line. And who are there? As even been said, more women, because it's 1 on 5 living with under this line. Young people. This is also very important to underline. This is 1 on 4 people who have to live under with a really low wage, and this is also mostly working in a limited duration contract, so precarious contract, and also working in which sector? Working in accommodation and forced services activities, or administrative and support services. So it means sector who are not under pressure of competitiveness, but essential worker at risk of poverty. And this is also very important to underline it, because as it's been said, wages are not the enemy of economy, of growth, but in contrary, this is really a motor of domestic demand and of European economy. This is very important. So first, I will let you the floor, Mr. Müller. You are senior researcher at ETUI, and I invite you to present an evaluation at 2 levels. The first one, I think it's to the impact of the minimum wage directive, about the reference value of action plan, and then also the potential impact of an annulation of the minimum wage directive. That we can already feel the potential impact, and this is really living already in some countries. So I let you the floor. Thank you.
Yeah, thank you very much. It's quite interesting because I was here in November when we actually celebrated the positive impact directive, and now we are back to the defensive struggles of ensuring its survival, essentially. Well, yeah, there we are. Okay, in the following 8 minutes, something on the political impact and the political impact of its potential annulment. And I think when we start or want to talk about the potential impact of the annulment, I think it's very important to first look at what we got already through the directive so far and what the danger is that we will lose. And there I think it sounds very simple and trivial, but I think one big impact of the directive was that issues like adequate minimum wages and the strengthening of sectoral bargaining in particular were on the political agenda, because I wrote about the European minimum wage directive for a long time and nobody was interested in actually what I wrote. But then in 2020, when the initiative started, it became an issue on the political agenda. Policy actors were interested. At national level, I'm talking about that in particular in the member states. What can we do about adequate minimum wages and sectoral bargaining? So that's one of the first and crucial impacts of the directive, to bring the visibility and to make apparent the importance of adequate minimum wages and sectoral bargaining, and all the issues related to it, fighting in-work poverty and wage inequality, and as you pointed out now, in particular also the gender pay gap. The second point is the minimum wage directive was a very important tool to create political pressure, because I mean, we as trade unions made this argument for a long time, how important adequate minimum wages in sectoral bargaining is. But with the minimum wage directive, we had a legal tool, and we could really create the political pressure on national actors to take that into consideration. And a particular importance were the reference values in the directive, which says adequate minimum wages, or if you want to assess the adequacy of minimum wages, why not take the reference values of 60% of the median and 50% of the average? And the same with collective bargaining and the support of collective bargaining, the obligation in the directive that every member state with a coverage below 80% has to establish an action plan was really helpful in creating the pressure and making national governments that were not that interested into supporting collective bargaining in the first place listen to us and actually start discussions about this action plan. In the following, I just want to show a little bit. Don't worry, I don't want to go through the table altogether, but I think it's important to show how the reference values actually contributed to better minimum wages. The first measure was that 8 countries we see here put it into national legislation, which means that the reference value actually guides the adjustment of minimum wages. And not going through the list of 8 countries, but I think in principle it's very important to see that first of all, countries were free to choose a reference value or not. So the directive left them the flexibility to do that. And even those countries, they did it, they chose completely different reference values. In Slovakia, we see 60% of the average wage. In Latvia, we see 46. So even there, the directive left them the freedom to choose which reference values. First of all, whether they choose the reference values and which one. So no direct interference into wage setting here. There was complete autonomy for member states because others did not choose any reference values. And that's the second measure how reference values guided the adjustment of minimum wages. In another 8 countries, the reference values have not been put into national legislation, but they were used as a political guideline. The primary example is Croatia, where we saw very substantial increases of minimum wages in the last few years, and that was always done with a political decree. And in that decree, it was referred to the minimum wage. So we increase minimum wages to this level because in the directive it says 60% of the median or 50% and 50% of the average. And that was the second mechanism. So out of the 22 countries that have a statutory minimum wage, 16 used the reference values in one way or another, and I think that is testimony to the positive impact the directive had in terms of minimum wages. Now, when we look at the transposition of the directive, the measures to promote collective bargaining, countries were a little bit more cautious in implementing those. My prime example, when we look at the transposition, Slovakia is a very positive example where we see concrete measures in there to support, in particular, sectoral bargaining. In terms of the action plans, we see very active debates in many countries. It's not just the unions that formulated their demands and wish lists that should go into the action plan. We actually have one country, Lithuania, already that adopted an action plan in order to support sectoral bargaining. So here we also see very positive implications of the directive. We also, in the discussion about the transposition, we also see already the negative impact of the opinion of the Advocate General, because in those countries, and the Netherlands and Poland are 2 examples, which haven't transposed the directive yet, the discussion essentially stalled, the discussion about the transposition process, because those political parties that are not that enthusiastic about the minimum wage directive say, okay, let's wait until we have a judgment, and then we see maybe we don't need to do anything if it's annulled, and we can save all the discussions now. So we see the negative impact in that respect already in various countries. So I'm very quick and with the time. Yeah. So what's the potential political impact of the annulment? And here I think it's very important to take into consideration the first impact I mentioned, that it was crucial to bring certain issues on the political agenda. Because what the biggest danger is, I think, is a shift of the political focus at the national level away from adequate minimum wages and strong collective bargaining. And as I said, we can see this in various countries in the context of the discussion about the transposition. We also see it in terms of the discussion. Yesterday we had the collective bargaining committee of the ETUC met, where we always do a tour de table, where the affiliates report. And there we had several countries that said the discussion about the action plan got more difficult as well. Because there we also see this wait and see. Well, let's wait. Maybe we don't even need an action plan. Huh? If the directive is annulled, then we don't need to have this discussion. And that's, of course, it's not only the narrow focus on adequate minimum wages and strong collective bargaining, but with it came the focus on the broader political objectives in work poverty and wage inequality. And there we also run the danger that this moves off the political agenda, in particular when we see now the competitiveness discourse coming back on the agenda. And we all know from the past that this often means we discuss wages as a cost factor and not, as Nicolas pointed out, a qualitative factor and an important factor for internal demand. The second one is, and that goes even broader, I think, and Roland, you mentioned that already, there is a big danger that if this directive, which essentially became the embodiment of social Europe for the last 4 years, I think it was the paradigm example, how the EU supports social Europe and does something that with a concrete impact on the wallets of workers at the end of the month. If this is taken away, obviously this will strengthen EU skeptical views. And I put the picture of protests in Greece in the context of the financial crisis. I mean, I don't want to say that we have similar events happening again, but it will definitely increase the EU skeptical view, and of course it will promote right-wing parties and their positions. So in that respect, that could be the broader political context implications, because as you say, Roland, citizens will, or workers will not understand why Europe can introduce measures that freeze minimum wages and that dismantle functioning collective bargaining systems. But then when the opposite is the case, when there is a measure that actually promotes these tools, then this is a problem. And then, of course, it will be a considerable setback for social Europe and political initiatives at EU level. And Isabel, you will speak more about that, so I don't even want to go into this into detail here. But everything that can broadly be linked with this broad definition of pay will be very difficult to pursue at European level in terms of directives. And Isabel, I hand over. I think there's a good link to your presentation now. Thank you very much.
Voilà. Thanks a lot. We already feel the risk of the annulment have concrete impacts already in the member states. So Isabel, I let you the floor for the last intervention today, the political one from the trade union. It's very important because we have to stop in 10 minutes. So I have to apologize because we won't have time for more questions. But I think it's very important to hear your voice and analyze a little bit. We've heard today, thanks to the expert of this morning, that it's not a political or very objective opinion from the Advocate General. So thank you.
Yeah. Thank you so much, Estelle, and of course, thank you for organizing this very timely event. And of course, the first point I would like to mention is the work has been done. The transposition of the directive has taken place. The deadline was this 15th of November of last year. So the train has departed the train stations. The train is on its way. It has in principle delivered what we need to have. We understand that some member states, Poland and the Netherlands, have still some questions, but in principle, we have it. So in principle, what the Commission should do now is to look at this transposition element, waiting for a judgment, of course, but it should not be, and it cannot be, stopping the train. So the train is on track, the train has delivered, has reached in principle the milestone it should have done, in particular in terms of reaching the deadline for transposition. And we see that the positive element of all of that is that it's already in national legislations. So for us, it's done, okay? So to go back will be very difficult. To go back very difficult because, of course, not only at the national level, but at the sector level, the trade unions have embarked on bargaining collectively, on moving forward, on action plans, even in some member states, as we heard. So, of course, the citizen out there will very much know what they can get. And they will be also voting against or for the governments that will promote minimum wage in their own country. So I think I don't see the whole picture as negative. And of course, we are in a situation by which, of course, the trend might be stopped. However, we have, in particular, on the basis of a very, and it was mentioned quite prominently, paradoxical, incoherent opinion of an advocate general, by which we understand also that some of his opinions have already been put aside by the judges of the court in Luxembourg. So, you know, we might take it as it is. We might also take it as something very incomplete and clearly not to the top. What I would like to say is, of course, that it has been key for us as trade union to be mobilized in a so short period of time in terms of delivering what the judges have, or the advocate general has taken so much time to write. We have been able to deliver with the conjunctions of very high-level experts, internally and externally to the ETUC, to deliver a counter-opinion, to make the case for what is this directive about. And I think I would like very much to thank all the colleagues for that, and of course, Stephanie here present, the ETUI with Torsten, but of course, to be very much aware that it has only been possible because we had this earthquake back in time, 2007, Laval and Viking. And the shock here again was that Laval was mentioned in the opinion of the Advocate General as a follow-up of. No? So what we have now is the follow-up of. And of course, that was the bomb that resonated very much in the ETUC, and that could not be accepted. And that for us to be able to have the ammunition, the evidence, and the intelligence to react so quickly. So I think here, my message is it's important that anyone out there that has social progress in mind, and I will come back to that one, is well aware that you have to be equipped at all levels to be sure that you make the case for what you need to have and what you have fight for, even after its adoption democratically. So what we have is, of course, for us, in line that has been mentioned, but we'd like to mention something which will be even more important in the next mandate, and for which the ETUC and the European Parliament, the progressive forces, the SND in particular, are fight for, is to maintain whatever is happening in terms of either the revisions of the treaty or an interinstitutional agreement, is that the lawmaking process is not taken apart. That the Article 3 of the Treaty of the European Union says that the aim of the European Union is, of course, to work in a highly competitive, but this is the adjective, highly competitive social market economy. That's what we are here for, with three aims. The first one is social progress. The second one is full employment. The third one is the protection of the environment. So here we have to make sure that we anchor social progress as we have to do according to the treaty in secondary law. And I think this is exactly what has been done. And this is what the Advocate General has just forgotten, interesting enough, or not mentioned in particular. We need to have a social progress protocol in the treaties. With or without a change of the treaty, we can add that, but we need exactly to have that, to be able to move on towards upwards convergence, because the European Union is an initiative that should deliver for anyone here, for all citizens, and not just for businesses, as we seem to see in this new Commission. So the project of the European Union is the European social market economy, and this social matters, and it has to matter directly for the citizen, in particular when it's about wages. And I was also very surprised and even shocked, that was the second one, to see that wages is part of social dumping, and social dumping is good. How come? I would like to see how much the judge and the advocate generals are earning in comparison to anyone here out there, or in comparison to the one who should be entitled to minimum wage, which is a decent minimum wage. So I think here we have someone who is not really having a reality check what is happening. And the most problematic issue is, of course, that all of that is because of a problem which does not exist, because the whole the whole claim is about an issue in principle, without having a specific problem at the national level. And of course, this is something that we were able to showcase and of course to make the court, we hope, well aware with a counter-opinion to move forward in the right direction. However, it is where we are, what it is. We cannot change this claim. We cannot change the fact that the Advocate General has taken his competition glasses instead of his, I would say, more independent and certainly more objective glasses to look at the whole picture, as it has been mentioned. However, we have two issues to face for the moment. The first one is the timing, and the second one is, of course, what's next. The timing is not known. So there are rumors out there that the judgment might be coming very soon. The 6th of May has been put on the table, if I may say so. And we are checking, of course. For the moment, no confirmation from the registry of the court. And doing reverse engineering, the court has to inform that it will take a judgment in a certain period of time. And of course, we will know on the 1st of April if, looking at the registry, whether the judgment will come on the 6th of May or not. This is the first momentum where we will be present, and this is, of course, the most important, that we have been able to react so quickly on the top of many academics out there to make sure that the court has another view and, of course, another understanding of what is all at stake and why the Adequate Minimum Wage Directive is so important. So up to that, mobilizations, academically, most of those mobilizations must be academic mobilizations to reach the judges to make sure, indeed, that they have another sound of the flavor of what is social Europe and what is the European social model. The second one is, of course, what to do with the judgment, whenever this judgment will come. So, all of the discussions went along the line of what the Advocate General proposed, full annulment or part annulment. So, of course, should that be the case, we will make sure that, of course, we will contest. And there is many forms of contestations. There is also legal contestation, if I may say so. We will certainly be looking into embarking in another directive, with potentially another legal base that will help us to maintain the existing protections of workers in terms of their wages. We will, of course, be advocating for maintaining what is already in the European legislation and the national legislations along the line of that directive, and in particular to encourage our colleagues to get inspirations in terms of their collective bargaining, collective agreement of what the directive has delivered. For us, as I mentioned, the train has delivered, and I think this is what we have to use to build on. Should, of course, the judgment be not a good one in terms of not recognizing the social dimension of the European Union, we will also have to mobilize, certainly politically, legally, academically, to maintain what has been adopted democratically so far. It has been mentioned, we also have identified and mentioned in our counter-argument, counter-opinion, that there are a lot of directives dealing with pay. Of course it is. It's part of the working condition, if not the first very important one. So, of course, one worst-case scenario would be that, oops, the Adequate Minimum Wage Directive does not work as such. So do we have to revise all of the others? And I would say we have to say no, we can't. Because here again, there are a lot of argumentations that have been developed that works against, that speaks against that. So I do think that much more than the Minimum Wage Directive, this train has also a lot of importance, and it is for us very important that it does not stop at the gate of the Court of Justice of the European Union in terms of we stop the clock, which seems to be quite trendy for the moment, but we move on, and we move on in the same direction for social progress, whatever the judgment will be. And I think the message that ETUC would like to give to all of you, being from the political side, being also from the academia, being also the practitioners out there, being also the trade unions in Europe. Thank you.
We really have to close this event, this very important event. We close on a very positive note from you, Isabelle. It's very good, but I have to avoid. We will stop breathing until the decision of the court, because we understand it won't be a stop, but it won't be a very good signal. And surely during this mandate and legislature, because for us, we don't have legislative initiative to come normally, but we are waiting for an action plan for the implementation of the European Pillar of Social Rights. So one of the most basements would be really in danger if the court take the worst case scenario, as you said. So we will stop breathing and waiting for the best decision of the court anyway. Thank you very much for S&D also to organize it. Thank you for coming. We will be at your side anyway. I will just finish, because the worst decision of the court will be very bad. But I will just conclude with the words of one of our speakers to the workers will not understand why business-friendly EU governance prescriptions on wage cuts are legal, while a labor-friendly directive on adequate minimum wage is not. Because one of the big dangers of a worst-case scenario decision of the court would be also a tapis rouge for the far right. And this is also a democratic danger for us in this parliament. So we hope that your voice will reach the court in the day to come. Thank you very much.